Hello everyone, Andrew Bethel with the Bethel Law Corporation, and today we're going to be discussing inheriting property, property taxes, and propositions. So last November, that is November of 2020, as I'm sure we're all tired of hearing about, we did have some elections, and with a new election cycle means a new set of propositions for us here in California to vote on. Typically, these propositions don't really affect too much the world of estate planning, but every so often one of them does, and it just so happens that this past year, Proposition 19, which narrowly passed with about 51% of the vote, does actually affect estate planning. Proposition 19 affects everybody who owns real property in California. Now, that's regardless of whether you have a trust or not, or whether you have a will or not. Everybody who owns real property is going to be butting up against what Prop 19 has changed. Now, before we get into the changes made by Proposition 19, I do need to discuss property taxes in general, as well as Proposition 13 and what it does to our property taxes here in California. If you already have an idea of how those two things operate, then you can skip ahead to this time code where we discuss Proposition 19 in particular. Before we get into Proposition 19, we have to discuss property taxes in general a little bit. So property taxes are taxes levied on you by the county assessor's office, and the value of that tax is based on their assessment as to the value of your property. Now, those property taxes fund a lot of different things, but mostly they go towards funding the schools in the area, as well as a few other smaller government functions. Now, as you are probably well aware, the value to your house and your land does fluctuate in a marketplace. So Proposition 13, which exists here in California, does allow county assessors to adjust the value of your tax by adjusting their assessment as to your property's value each year, but it's limited to an increase of 2% per year. That's the max. And of course, it can always go lower, but you're pretty hard-pressed to find a county assessor's office who's going to lower your taxes that year, especially with the real property market here in California being that what it is. Now, Proposition 13, in addition to having that limit to the reassessment number, also gives us a couple other benefits. Firstly, when you transfer property, there's typically a reassessment on that value. The county assessor can totally reassess it for that date of transfer, which usually is the sale of property. It could also be the gift of property as well. But what Proposition 13 does for us is give us a couple instances where those transfers are exempt from reassessment. Now, those are transfers from parent to child, as well as transfers from grandparent to grandchild, if that intervening parent has passed away. And those transfers go either way. So it can either be child to parent, or grandchild to grandparent. Again, if that intervening parent generation has passed away. Under Proposition 13, the county assessor cannot reassess the property if one of those transfers takes place. Next, we'll discuss Proposition 19. But first, let's discuss the two little benefits that 19 did add. So previously, under Proposition 13, if you moved within the same county and you were over age 55, you were allowed to carry over your property tax assessment level. Under Proposition 19, this has been opened up to where if you move anywhere in California, you can carry your property tax assessment level with you, again, so long as you're over age 55. Additionally, Proposition 19 allowed for the same carrying of one's property tax assessment level if they're moving because they are the victims of a wildfire. So those are the two benefits added in Proposition 19. But it did also create one big erosion of the benefits that we've had under Proposition 13. So as I mentioned before, under Proposition 13, there are a couple transactions or transfers of property that are exempt from reassessment. That is transfer from parent to child and vice versa, or grandparent to grandchild and vice versa, so long as that intervening parent generation has passed away. Under Proposition 19, these transactions do still qualify for an exemption from tax reassessment, but there's a condition on that. Now they only qualify if the party transferring the property, if that property was their principal residence, and so long as the party receiving the property moves into that property within 6 months of the date of transfer. So what that means is if mom transfers her property to her son, and if son wants to keep mom's tax reassessment level, son has to move into that property, and mom has to have that property registered as her principal residence prior to that transfer. Additionally, Proposition 13 does have a cap on the value of the property that is excluded from reassessment here of $1 million. So what that means is, so long as the property is under $1 million in value, you qualify for that reassessment exclusion. If the property is over $1 million, then the county assessor can reassess the property on anything above that $1 million value. So for example, I transfer a property to my son for $1.5 million. The county assessor can only reassess that $500,000 for new property taxes. They have to leave that $1 million alone. In the estate planning world, the carryover of one's property tax assessment level has been one of those constants that we can usually kind of bet on when it comes to drawing up our clients' distribution plans. Our clients sometimes have multiple pieces of property or have children living in different places, so they want to customize their distribution. For example, parents might have 2 pieces of property, so they decide to leave one property to each of their 2 children. Or they have children living in different places, one of which maybe already has a home, but the other one lives closer by and might need more help financially. So what the parents can do in that situation is they can transfer the property to one child while leaving funds or liquid assets to the other. But they've had that flexibility to just say, you know what guys, you get everything but you split it. Now under Proposition 19, parents or grandparents' hands are kind of forced a little bit within the estate planning world. If you want to transfer property down to your children and the children do not move into that property, now those children are stuck with a reassessment. Now, if you bought the property, maybe 5-10 years or so before you passed away, the reassessment level isn't going to be too big of an increase to where it would be sudden and shocking. But think about it. If you've lived in the same piece of property for 30, maybe 40 years, such as the family home, and you transfer it down to your children, but they don't move into the property, maybe they have their own house or they live a little bit too far away to uproot themselves because their job is located somewhere else. Now they're stuck with a huge property tax reassessment, big property tax bill, because you've had the property for a long time, but the kids don't move into it once it becomes theirs. The other consideration is not so much in the estate planning world, but occasionally there are instances where parents or grandparents want to gift property to another family member outside of their trust. Now they also have to consider the property tax assessment level and whether or not the recipient has the ability to afford to pay those property taxes. So it does not inhibit one from drawing up their distribution how they want, but it does kind of place additional restrictions and kind of force one's hand a little bit when considering their ultimate distribution. Finally, I don't want to say that we're all doom and gloom here and we're stuck. Now, currently we are living under these rules. They did go into effect February of 2021, but there is a little bit of light at the end of the tunnel here. Howard Jarvis Taxpayers Association has begun the filing of paperwork in order to have a new ballot initiative put on the next round of elections. And what it would do is repeal some of the erosions put in place by Proposition 19 and actually uplift some of the limits placed as far back as Proposition 13. So what they would do is eliminate that principal residence restriction, meaning that whatever property you own, you can transfer it to, for instance, your children or grandchildren, again with intervening parents having passed away, without a tax reassessment hit, regardless of whether it is your principal residence or not, regardless of whether they ultimately move into the property or not. Next, the ballot initiative would up that $1 million limit, which is still in place under 19, up to $2.4 million, and then tie its increase to inflation. So what that would mean is previously you can transfer property without that tax reassessment only up to $1 million in value. Anything above that would then get reassessed. If this new ballot initiative were to make its way onto the ballot and pass, that number would be upped to 2.4 million and be increased every year, presumably, with inflation. What that means typically is parents who own property for a long period of time and the surrounding area gets built up, forcing their property values to go way up, higher than maybe they expected. Now they can still pass that on to their children without the children having to necessarily suffer the tax hit of having a huge property given to them. Now, they are receiving a property, but it does bootstrap them into that big tax bill, kind of forcing their hands as to what to do with the property. But, like I said, this is a light at the end of the tunnel, but it does not mean that is where we are now or necessarily be where we will be in the future. Again, we're currently living under the Prop 19 rules currently put in place. If this ballot initiative does make its way onto the ballot, we would still have to wait until that point. We still have to go through that election, and even if it passes, it would still have a grace period before it would then go into effect. So as of right now, under Proposition 13 and 19, if you transfer property to a child, the child needs to move into that property, and that property must have been your principal residence in order for there not to be a tax reassessment. The same holds true for a transfer from grandparent to grandchild if that intervening parent has passed away. And remember, this transfer goes the other way. So grandchild to grandparent or child to parent. With all that said, passing real property down to the next generation through one's estate plan is the principal way to build what's called generational wealth in one's family. What 19 and 13 do is create some rules that we do need to take into consideration when drawing up your estate plan. So if you do plan on passing property down to the next generation, do give us a call and we can discuss how to navigate these rules and such that your children won't be stuck with a huge, sudden tax burden down the line. And again, remember, this affects everybody in California, whether you have a trust or not, whether you have a will or not. If you own property, then you do have to abide by these rules. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.